Moving on to criminal procedure code. This is a proceedings which concern with which deals with the criminal cases where offences or crimes are committed against the society. The impact that the criminal judicial justice system creates on an individual is far more than a civil proceedings. Why it is more? It is because it has got a double impact. One, impact on the accused. The moment a case is filed, a criminal complaint is filed, his personal liberty would be taken away, maybe through an arrest. Worse than that, it would impact his psychology. He would be a broken man, mentally as well as emotionally. But the second impact of the same system is on the family of the accused. The stability of the family would be sacrificed through arrest if he is a breadwinner of the family. Stability would be affected even if he is not a breadwinner of the family, because that may lead to stigmatization of the whole family. The society may refuse to interact with such family where a person has been accused of a crime. So therefore, here speedy justice and a justice in real sense becomes very, very important. The impact which I mentioned on accused and the family of the accused, it is uniform to all, poor, rich, important, not so important. But when it comes to poor, the impact would be multifold. First, where the poor is a victim of a crime, the poor goes to a police station to file a complaint. The complaint may not be registered. That is the first hurdle that he has to cross. Even if a complaint gets registered, action may not be taken. Second hurdle that he has to cross. Even if action is taken, the other affluent party can get a bail with effective representation and then intimidate this complainant. That is the third situation. So the impact of criminal justice system on poor is multifold, even if he is a victim of a crime. And look at the impact where the poor is accused of a crime. Now here the impact is widely different from the other side. The impact would be like prison violence. So as the prisons are overcrowded and there is no classification of prisoners, hardened, regular, amateur, first timer, all are put at one, and these first timers who are meek and humble, they get crushed in the prison violence. Homosexual abuse, as the prisoners are kept away from the opposite sex, the natural urge of prisoners would be satisfied through these homosexual abuses. And again, who are targeted in this? The meek and the one who cannot defend themselves. Health problems. Now this is another thing where a person who is already suffering from diseases because of poverty and lack of nutrition, and these diseases gets contagious and spreads all over when they are cramped in a crowded situation. Mentally ill prisoners. Now these are the prisoners, there is no record as to how many mentally ill prisoners are there in our prison, but these mentally ill prisoners are again they also lead to a kind of violation of human rights. Families of the prisoners, as I already mentioned, the impact on them is also can be felt. Now setting in a criminal justice system into motion itself can be an access to justice. Allowing a poor to file a complaint, allowing a poor to insist upon investigation can be considered as a setting in motion of a process, access to justice. FIR copy. A copy of FIR, he is entitled as a complainant at no cost, and if FIR is not registered, then he has a right to approach a superintendent of police and complain about the no action by the police. Even if he cannot move the superintendent of police, he can file a private complaint with the magistrate, judicial magistrate, and through that he can ensure the enforcement, the setting in motion of a criminal justice system. Assistance of lawyer can be sought at all these stages. So therefore, there is a provision in CRPC where poor can access justice by setting in criminal justice system into motion. So in Sukhdas versus State of Arunachal Pradesh, the court said that the court interpreted section 304 of CRPC and held that a conviction of accused in a trial in which he was not provided with legal aid would be set aside, being violative of Article 21. So any conviction without legal aid can be set aside. Further, coming to the second part of access to justice, that is provide empowerment of a poor man. How do we empower a common man? By getting hold of all the documents which police are having. Number 1, police report, first information report, statements recorded under 161 of CRPC, any other documents which are relevant. So all these, if they are available to the parties, then that would be an empowerment of the parties as well as access to justice. Coming to last discussion of my topic, that is role of advocates in access to justice. Beginning, I want to mention, as you are already an advocate and coming for an higher studies, you and me, we all are privileged class because we have a monopoly over our profession. No other person can interfere with our profession. When we enjoy the monopoly, who has given us this? It is the society, it is the state. So as a result of that, we are duty bound to provide them with the service to the society in the form of legal aid. So in American justice system, the bar mentions that defending liberty and pursuing justice is the paramount function of advocates, to promote meaningful access to legal representation, and the American system of justice for all persons regardless of their economic social condition is considered to be the paramount duty of the advocates. Magna Carta mentions, to no one will we sell, to no one will we deny or delay right or justice. This is again a statement which goes well with the advocates. Legal service which advocates are expected to provide means providing assistance, a legal service in the field of law to the needy person, and it is not a charity. Please remember, legal aid is not a charity, but it is a duty of the welfare state, and we being the beneficiaries of the state, the duty falls on us. Advocates Act 1961 provided for a section 6 which said every advocate shall practice, I am going to read out the complete section for the benefit of discussion. Every advocate shall in the practice of the profession of law bear in mind that any one genuinely in need of a lawyer is entitled to legal assistance even though he cannot pay for it fully or adequately, and that within the limits of an advocate's economic condition. Here both the duty as well as exception is been said in one breath. The duty is to provide legal assistance to the needy. The exception is within the economic condition, limits of the economic conditions of the advocate. But this exception has led to various interpretations, which has led to a situation that section 6 became mere letters of the law. So, to overcome this, the court has come up with, the legislatures have come up with a new law which provides for regulation and maintenance of standards in profession, protecting the interest of clients and promoting rule of law. So, these are the three objectives. So, to provide standards in the profession, they have established ombudsman. To protect the interest of the clients, they have established a legal services board, and to promote the rule of law, they have created the objects. So, the first three objects are concerned with our topic, our discussion, supporting the constitutional principle of the rule of law, protecting and promoting the public interest, and improving access to justice. So, here I want to highlight one thing. So, the difference between the earlier legislation and present legislation is that there are no exceptions when it comes to providing duty to the towards the needy persons. Here the advocate is duty bound to provide free legal aid, and the financial weaker section that is been defined under the bill. So, this is the major difference between the two, and here I bring end to my discussion on access to justice and the poor. Thank you very much.